Very good morning to you all. Nice to see you here.
And please be seated. Please be seated in silence so that we may start, as we have lots of work ahead. Please be welcome to this joint session of both the Committee on Liberties, Justice and Home Affairs and the JURI Committee, the Committee on Legal Affairs. We're about to hear from Commissioner-designate Mr. Didier Reynders, to whom we warmly welcome to this joint session. Please be welcome. This hearing is of the utmost importance for both of us committees, as justice portfolio fully falls into the competence of both of our committees, as it has been designed by the mission letter addressed by President-elect Ursula von der Leyen. It is only obvious that it falls fully within the competences of the LIBE Committee, Committee of Liberty, Justice and Home Affairs. As, first of all, the portfolio is in charge of ensuring the rule of law effectively upheld within the European Union, including the proposed enhanced and enlarged European rule of law mechanism, which also affects democracy and fundamental rights, ensuring full respect of protection of fundamental rights enshrined in the Charter of Fundamental Rights of the European Union, which entered into force along with the Lisbon Treaty 10 years ago, and its binding law according to the jurisprudence of the European Court of Justice. It also affects the impact of the Charter of Fundamental Rights on privacy, according to the digital age, which is also one of the portfolios designed by President-elect Ursula von der Leyen in the future Commission. Also makes an impact on the work towards an effective implementation of data protection package as a consequence. And most importantly, when it comes to the Committee on Justice and Home Affairs, Civil Liberties, Fundamental Rights, Justice and Home Affairs, we have to make sure that we are ready to improve the state of judicial cooperation among the member states of the European Union based on mutual trust and mutual recognition as enshrined in the Treaty of Functioning of the European Union, which is of the utmost importance, and proper implementation and enforcement of the EU law in our field of action, the development of the capacities of the agencies related to the LIBE Committee, which are numbering in 9, so your portfolio, justice portfolio, will create the conditions of an effective functioning of the European Public Prosecutor Office, which have completed the process to appoint the new head of the European Public Prosecutor Office, which is to be effective early in 2020. Then we will also be making sure that we contribute to a coordinated approach on the implications of artificial intelligence in our field of action and lawmaking, ensuring that company law promotes small and medium-sized business strategy, and effective international multilateral cooperation in the field of civil and commercial justice as well, timely and correct transposition and implementation and application of the Union law in all of the member states. So may I recall that this justice portfolio happens to be central to the strategic agenda of the Union in the coming years and challenge ahead to achieving European justice area, as it is the political will and the legal mandate of the area of liberty, justice and security, Title 5 of the Treaty of Functioning of the European Union, based, as I said, on mutual trust, mutual recognition, and in full compliance with the values enshrined in Article 2 of the Treaty of the European Union, that is to say, the once called Copenhagen criteria, overcome throughout the process, we discussed, and we called the Copenhagen dilemma, as to binding principles and values and fundamental values which are binding law for all of the member states, and that the EU law is above in its field of action and binding to the member states. So I will now pass the floor to the co-chair of this joint session, Mrs. Lucy Netzinga, which is the URI chair. The floor is yours.
Thank you very much. It's a delight to be here, and I would also like to extend a warm welcome to Mr. Reynders. I hope that this will be a very productive session for all of us. I know that URI are very pleased to be here sharing this session, and we will be particularly interested in the areas of consumer protection, which are very much part of this portfolio. I would like to focus on some of the procedural aspects for this morning's session. According to Annex 17 of the Rules of Procedure, which contains the guidelines for the approval of the Commission, Parliament will evaluate the Commissioners designate on the basis of their general competence, European commitment and personal independence, and it will assess the knowledge of their prospective portfolio and their communication skills. I would like to remind you that Parliament has submitted a preparatory questionnaire to the Commissioner designate, with 2 common questions drafted by the Conference of Presidents and specific written questions. The Commissioner-designate has replied in writing to the questionnaire, and the answers have been distributed to members in all languages. I would also like to remind you that the Committee on Legal Affairs, responsible for the declarations of financial interests, has raised no objection to the holding of this hearing. The debate will be structured as follows. The Commissioner-designate is invited to make an oral opening statement of no longer than 15 minutes. After that introduction, there will be time for 25 questions from the members. The debate will be held in accordance with the slots of 5 minutes each, with 1 minute for the question and then a 2-minute answer from the candidate Commissioner. In the case of a follow-up question, the question should not be longer than 1 minute, with 1 minute also for the reply. The first round of 7 questions will be asked by the coordinators of the political groups. The second round of 18 questions is based on the overall distribution of questions among the political groups, including a representative from the non-attached members. At the end of the hearing, the Commissioner-designate will have 5 minutes for a closing statement. Please be aware that we, as chairs, will have to be very strict in ensuring that the speaking time is respected. Otherwise, the last speakers will have no time left to ask their questions, and the Commissioner-designate will not be in a position to give justice to those questions either. Therefore, I will warn you that if you do exceed your time, we will be obliged to interrupt you, and I thank you for your understanding in this. Interpretation will be provided in 23 languages. You can therefore use your own language, keeping in mind that what you say needs to be interpreted, and therefore it would be helpful if you did not speak too quickly. The debate will be live streamed on the Parliament's internet site, and it will also be possible to access a video recording of the hearing on the same site. I will now hand the floor to Commissioner-designate Reynders for his presentation. Mr. Reynders, the floor is yours.
Thank you very much. Mesdames les Présidentes,
Co-chairs, members of Parliament, I'm very happy to be here to introduce myself to you this morning. It's nice to see so many familiar faces. I would like to talk to you today about how we're going to work together in the future if you put your trust in me within the framework of the mandate given to me by the President-elect, Mrs. von der Leyen. She has asked me to lead the Commission's work on rule of law, justice and consumer protection. As you know, I am a former Member of Parliament, and I have a deep respect for the role of the European Parliament. I think there is real value in your contribution to the European project. Let me begin my comments by a couple of thoughts of a more personal nature. The first, which is very important to me, is Europe's place in the world. 20 years ago, when I became minister for the first time, Europe was divided. It was trying to tackle the impact of the fall of the wall. Over the last 20 years, many things have changed, and we can be proud and happy, I think, of what we have achieved in Europe. We are carrying out policies and adopting legislation for the well-being of our citizens rather than fighting over territory. We have preserved our diversity through our cultures and our languages. If I am confirmed as European Commissioner, I make a commitment to work with you in order to deepen European integration. I am amongst those who want more and better Europe. If we want to have influence on the world stage in these changing times, the only way we can do this is by being united. The reality that we face is that the world around us is ever more divided and unstable. The values we hold dear are threatened by those who want to go back to a more nationalist discourse, a more populist discourse that should belong in the past. Our values are threatened by nations that want to dominate rather than cooperate. Our main goal is to try and protect what the European Union has achieved: peace, security and well-being. We also need to promote our common values, our support for multilateral institutions and sustainable growth and social progress. We should be determined when it comes to defending the rule of law, democracy and our fundamental rights. That means we need to do the same within the heart of the European Union as well. My second thought is even more personal to me. On Saturday, the 14th of September, I learned that serious accusations had been made against me by a person who was deliberately trying to damage my reputation. This person publicly stated that they wanted to stop me becoming European Commission. I denied all the allegations that appeared in the press. My lawyers got in contact with the prosecutors to have access to the file within this information procedure. On the 27th of September, the Crown prosecutor, in full agreement with the public prosecutor, dismissed the case as there was no evidence of any wrongdoing. My lawyer will deal with the new allegations made by the same person in the same way. All of us, unfortunately, can be at risk of such malicious allegations, and I wouldn't wish on anybody what my family, those close to me, my children, my spouse have had to experience over these last 15 days. The rule of law also means the presumption of innocence, and I just want to be very clear with you about this particular matter. Ladies and gentlemen, exactly 20 years ago, in October 1999, Antonio Vitorino was named the first commissioner who had the portfolio of Justice and Home Affairs. I would just like to pay tribute to him, as well as his successors, particularly Mrs. Vera Jourova and Mr. Franz Timmermans, for their courage and determination. If I become commissioner, I will work very closely with them. I am delighted to have been put forward as President-elect to be the Commissioner designate for Justice, as well as consumer protection and respect of the rule of law. These three facets of the mandate are closely linked. They're built around the guiding principles of trust, inclusion and fairness. These will be key to these different policies and will guide my actions.
As for the rule of law, I believe that we must project our values outside of Europe. We must uphold them inside Europe. As Commissioner for Justice, I will work with the Vice President for Values and Transparency to ensure that the rule of law is upheld across the Union. I will work closely with the Commissioner in charge of Neighbourhood and Enlargement to ensure the consistency of the internal and external rule of law approach. This task is close to my heart. As Minister of Foreign Affairs and European Affairs, I have called for a more active commitment of the European Union to protect and promote the rule of law. This is a prerequisite for our values. There can be no democracy and respect for fundamental rights without respect for the rule of law. Fundamental rights are effective only if they are protected by independent courts. Democracy is protected only if courts can ensure the respect of the freedom of expression, media pluralism and electoral rules. The rule of law creates mutual trust, so important for our internal market. Most importantly, respect for the rule of law is essential to ensure citizens' trust in the European project. Our responsibility is to preserve the rule of law in each and every member state. A number of ideas have been presented, including by this House, to give us the tools to deepen this work. In July, the Commission presented its proposals for a comprehensive European rule of law mechanism. I will promote a rule of law culture, prevent the development of rule of law concerns, and respond when necessary. I will lead this work and want to see this new mechanism up and running next year with an inclusive, non-discriminatory and preventive annual process. This will lead to an annual report and be backed up by the Justice Scoreboard. We must use all the tools at our disposal. The monitoring will cover all member states, but will go in more depth in member states where particular risks have been identified. I will pay particular attention to ensure the objectivity and fairness of this monitoring and how we build dialogue and ensure that we share best practice to help member states. It is essential that the Parliament and the Council are fully involved. We also need to coordinate better with national parliaments. We have the same aims and ideals. Trust me, I will not hesitate to act whenever the rule of law is in danger. I will not compromise when democracy is at stake. Mesdames et Messieurs,
Members of Parliament, adapting our judicial systems to the changes we are seeing is a major priority for the decade to come. We need to strengthen cooperation in civil and criminal matters. European citizens have the right to live and work in the EU with the full respect of freedom of movement. It's also about respecting our diversity, but guaranteeing our different legal traditions at the same time. But this should not be a hindrance to our freedom or our security. I will work to build an atmosphere of trust between our different legal systems.
concerning the European arrest warrant, I will continue to monitor its application and work closely with you and with member states to continue to improve it. We need to take a careful look at what needs to be done after the compliance assessment now underway. We will consider whether infringement proceedings are necessary. In light of the compliance assessment, I will also seriously consider whether to bring forward a proposal to revise the European arrest warrant. I will also look into how prison conditions in the Union could be improved, and I will explore the idea of establishing minimum standards for pre-trial detention in order to strengthen trust. Une tâche immédiate consistera à rendre opérationnel.
One immediate task will be to make the European Public Prosecutor's Office operational as soon as possible, and I welcome your role in getting an agreement on the public prosecutor. I recently was in contact with Mrs. Kovesi, and I'm sure she will be doing a very good job. It is important for us to incorporate new technologies so that we can modernize our legal systems. That's a major challenge. This is going to help us create a more effective legal system, one that's more accessible to our citizens. We have to ensure that the law is respected, but also that fundamental rights are respected. Europe is a world leader when it comes to data protection and respect of fundamental rights. One of my priorities will be to ensure that these fundamental rights are fully protected in the digital era. I will work closely with you in order to find the right balance here. We need to make sure that the new legal framework for data protection is fully implemented and at the same time continue to promote our values and our standards on the world stage. I will work with my colleagues on a coordinated approach when it comes to looking at the human and ethical implications of artificial intelligence. I look forward to the new possibilities opened up by these new technologies, but trust and safety have to remain our main priorities here.
Inclusion and fairness drive my approach to consumer protection. We can rightly be proud of the level of protection in Europe. We should not be complacent. We must continue to innovate and adapt to the rapidly changing environment and new technologies, offline and online. Our task is to work for fairness and sustainability in society, for the efficient functioning of the single market. This means looking more closely at both the supply and the demand sides of the business and consumer models. Company law can be a key tool to promote the shift to a sustainable economy. Consumers should be fully empowered, properly informed, and encouraged to make sustainable choices. Consumers individually have little power, but together they are very strong if they can act on an informed basis. This purchasing power can help create a sustainable economy. That is why I will also push for swift adoption of the proposal on representative actions. Collective redress possibilities are very much needed by European consumers. We must continue to crack down on dishonest and aggressive selling and protect vulnerable consumers. We need to keep a high level of vigilance about the risk of dual quality products. It is unacceptable for consumers to be misled into believing a branded product is the same as elsewhere. We expect the same fairness wherever a consumer lives. The starting point must be that products we buy are safe, whether produced in Europe or elsewhere. I will look into updating the General Product Safety Directive so that all players in the online supply chain reduce the number of unsafe products. I also want clear rules in terms of liability for all providers involved in the online consumer journey. Finally, I intend to place particular emphasis on effective enforcement. A large amount of consumer law has been adopted in recent years. We now need to ensure it is effectively enforced, both inside the Union and with our international partners. Mesdames les Présidentes,
Chairs, members of Parliament, I have spoken a lot of our accomplishments over the last 20 years. I think we have the right to be proud of what we have achieved. We also have a duty to look to the future. That starts with listening, and I will be attentively listening to you all throughout my mandate. There are millions of young people who are out in the streets who are calling for a more sustainable future. They are a source of inspiration for us. They are calling on us to act. Together, I think we can achieve great things. I hope you will put your trust in me. Thank you.
Thank you, Commissioner-designate Reynders. And now, as announced, we're about to get started with a round of questions up to a maximum of 25, all of them with the very same structure. It's going to be 1 minute of a question, then 2 minutes for a first answer, 1 minute for a reaction from the bench, every member, and then a final minute from Commissioner-designate to close the point raised in every single question. We're going to get started with the usual round of representatives of the political groups. 5 minutes each one of the members which are about to intervene, getting started with the EPP representative, Mr. Andrzej Halicki. You've got the floor.
Panie Przewodniczący.
Thank you very much, Chair. Indeed, Chairs. Congratulations on your appointment to this very important role. I'd like to start the round of questions with a pivotal, indeed an essential question. The Commission communication last week on the enhancement of community measures on the rule of law and possible responses. Respect for European standards and rule of law, as you rightly said, is essential for establishing a trust between the member states, and obviously this has a great impact on the rollout of all politics having to do with the smooth running of the authorities, the judicial authorities and so forth. And this also ties in with policy and internal market measures. How will you ensure the smooth running of the new mechanism for the rule of law in practice? How will you see to unity in this initiative when it comes to the rule of law? As you and we are all aware, some member states are undermining the judicial system. We have heard of various examples of interference in the legal system, cases of corruption, and indeed threats to the freedom of expression and threats to the plurality of the media. To your mind, how can we respond to these infringements against the rule of law when some member states just don't want to play ball?
The timing, the importance of the timing, because we've got work ahead and it's going to be scheduled for the next 2 hours and a half. So it's important that we all refrain ourselves to a first minute of a question, then respect the 2 minutes of an answer, and then final minute to react. Thank you.
Thank you, Mr. President. Je remercie Monsieur Haliki pour ça.
Can I thank Mr. Halitsky for his question on the rule of law. The rule of law is going to be front and centre during my mandate, if I'm confirmed. For 3 years in Council, I've been pleading for a peer review system on the rule of law. I know that this House in October 2006 produced a resolution on that subject, and the July report is very important as a part of the overall démarche. Step number 1 will be to get the Commission to produce a report on human rights. It's going to be not just rule of law, it will also be a wider area. And in the first year of the Commission, I would come back with a paper which would be a basis for discussion both in the Parliament and, I hope, in Council. But these are not instruments in the toolbox. You're asking for what else can be done. Article 7 has been triggered vis-à-vis 2 member states, Poland by the Commission, Hungary initially. After Parliament expressed a number of complaints, there is the infringement proceedings system vis-à-vis the Court of Justice, and it's also possible to attempt to dialogue with the countries concerned, and I would certainly do that. This would no doubt mean going to the countries concerned from the start of the mandate, because we can use the tools available, for example, the Venice Commission or Greco, to advance legislative proposals which are more in line with the realities. So rule of law is one thing, but there's a wide range of tools in that toolbox available to the Commission, and what I hope is that it wouldn't be necessary to embark on Article 7 because there are other ways to obtain satisfaction, but that will materialise in the course of the next few months.
You got a second minute to react.
Chciałem dopytać na temat.
Thank you very much. Yes. I'd like to know what you intend to do in terms of monitoring exchange of information and establishing good practices, because when there are situations of risk, we have to act swiftly and tangibly.
Final minute, Commissioner Reynders.
Merci.
Thank you. There are other formats available. I've indicated infringement proceedings, for example, but there's a big debate which is currently underway on the multi-annual financial framework, the MFF. And against that backdrop, many have called, and I have, for conditionality between the MFF and rule of law. I believe that we'll get an agreement rapidly between the co-lawmakers on that subject, because this would then mean it was possible to take direct budget action with suspension or losing money altogether in the event of a generalised failure to uphold rule of law obligations. This is not something which is entirely in the hands of the Justice Minister. There are other departments. But conditionality, rule of law, is an important thing. And I take the point very well, Mr. Halitsky. It's necessary to respond in the event of failure to uphold.
And the representative, Mr. Tierno Volken, you've got the floor for 1 minute.
you very much, Mr. Reynders. Welcome to our hearing. I regret that you didn't mention corporate sustainability and due diligence in your first remarks. For us, transparency is a key element in ensuring corporate accountability for identifying and addressing risk of adverse human rights impacts, and as well as for fighting climate change and protecting the environment. The current EU Non-Financial Reporting Directive, which introduced the requirement for larger public companies operating in Europe to disclose information on environmental, social, human rights and anti-corruption matters, was a first step in the right direction, but has proven to be in serious need of revision in order to make it fit for the purpose. Are you going to present a legislative initiative amending the EU's non-financial reporting directive? And remember, today more than 84 civil society organizations are demanding action of the European Union. The S&D Group and I personally agree with them that we clearly need more than pure guidelines.
Thank you. Now, Commissioner Designate, you got 2 minutes to respond.
Thank you, Chairman. I want to say that I've mentioned our obligation to work on sustainability in my introductory remarks. I want to go maybe forward and further on that, Mr. Volken. First of all, we are all committed as European Union, but as member states also, to fulfill our engagement about the SDGs, the Sustainable Development Goals at the level of the UN. And you spoke about some actual regulations. There are different kinds of non-financial information requests to the listed companies. There are some specific elements, but it's true that in the company law, it's maybe important to go further, to go forward about different requirements. If we are organizing a real sustainable policy, we need to ask to all the companies to change maybe their way to think about the social interest. Social interest is not only a short-term vision for the shareholders and for the profit of the shareholders, it's also a medium and long-term vision. I mean, a vision about climate, about the local communities, about environment, about different other stakeholders than just the shareholders. And I'm very committed to work with you and with the Council about the way to install in the company law new requirements. You spoke also about human rights. It's the same. There are some voluntary commitment for the moment at the level of many companies, but it's not enough. I'm sure that we need to go to a real change in the company law to ask more obligations about the social interest of the companies. And I'm sure also that it's quite important to discuss about the supply chain. If you have the requirement for one company to explain a more medium and long-term sustainable policy, it's important to ask to such a company to verify what is the situation in the supply chain.
Now, Mr. Volken, you got a minute again.
Thank you, Chair. Mr. Reynders, as you avoided a clear answer, what concrete steps will you take to ensuring EU companies and those operating in the EU adhere to globally recognized human rights as well as to the protection of the environment? And what will you do to improve the access to judicial remedy for those who have suffered as a result of corporate malpractice by European companies and companies operating in the European Union? I really want that you today commit to a framework which gives European citizens clear rights and helps to ensure our globally and helps to ensure our to enforce treaties we entered on the global level, so UN standards or OECD standards. So please make a clear answer to this follow-up question.
Your time again, Commissioner Designate.
My answer may be very clear. Is yes, I'm committed to do that, but I'm committed to do that in different kind of frameworks. I was speaking about the company law. I was listening to your remarks about the capacity for the citizens to act. For the consumers, I will explain that maybe later. I'm sure that it's important to go to a collective redress, but I'm committed to work on the best legislative basis to be sure that for all the economic actors, there's a real commitment to fulfill the engagement about the human rights And I'm sure that it's possible to do that in different legislative acts. But I'm very committed to do that, and my answer is very clear. You ask the question, do you will act on that? Yes, I will do that.
Now we move to Renew representative, Mr. Michal Smeka. You've got 1 minute for your question.
Thank you very much, Mr. Chair, and thank you, Commissioner Designate, for being here, and congratulations. Now, the rule of law, democracy, and fundamental rights are all central to the development and survival of our pluralist societies. But what we see today is a number of governments in member states actually using their majorities to undermine pluralism and to cement their power through law. So the question and the problem clearly is broader than just the law, as you yourself have acknowledged. So as Commissioner responsible for this new comprehensive mechanism, would you also expand its title so as to cover the full scope of Article 2, namely democracy, the rule of law, and fundamental rights? And my second question is, would you agree that one of the reasons that the EU has been slow to respond to this problem is the many divergent approaches taken by the different EU institutions, many proposals, many ideas, many benchmarks? So are you committed to deliver one single mechanism which would involve all EU institutions and which would take the shape of a binding interinstitutional agreement along the lines proposed by the Parliament in 2016? Thank you.
Thank you. Mr. Reynders, you got 2 minutes for your question.
Yes, thank you for such a question about the mechanism and the ideal, the way to go to a very comprehensive approach about not only the rule of law, the fundamental rights and democracy. For the moment, we are in a situation with the communication of the Commission where it's possible to work on a report on the rule of law. In some extension, I spoke about media pluralism and democracy, but it will be a report on that. You know that there's also, in the intention of the Commission, a report on the Charter. Is it for fundamental rights? So it's possible to come with also a report on that. We will work on a new strategy for the democracy, so maybe with a report also on democracy. So I will work on the rule of law as such, because you know it's a very long journey to organize such a process. We have discussed in some years here in this House, but also in the Council and in the Commission, about the way to organize such a process. But I'm sure that we need to work together. And to work together, that I mean maybe to organize a single one debate about all the different elements. The report on the rule of law, the report on the Charter, and maybe the report that we will have also on democracy. And if we are doing that, it's possible to discuss about an interinstitutional arrangement. A formal one, I don't know, because it will be long, maybe for a medium term, but to start immediately. And why not? I will propose that, to organize a working group with the three institutions. The Council was discussing about a peer review, the Commission with such a kind of different report, and the Parliament with your text of October, I'm sure, 2016, and to see how it's possible to build together the process. Of course, I will work first on the report on the rule of law, but how it's possible to build a process with an interinstitutional discussion on the whole issue, the comprehensive issue, like you said, rule of law, fundamental rights, and democracy. So I'm hoping that it will be possible to start such a working group as soon as possible.
Thank you, Mr. Reynders. Mr. Smeka, you got a second minute to react.
Thank you very much, and thank you for the answers and the commitment to work with the European Parliament. And this should be in line with the promise or the commitment by the von der Leyen Commission as a whole to grant the European Parliament the right of initiative and follow up on its own legislative initiative reports by Article 225. Now, can you explicitly confirm that this will also apply to this issue and to the report that the Parliament has produced in October 2016? I'm asking because in the new Commission proposal and also in your written answers before this hearing, you kind of rejected the idea proposed by the Parliament for an independent monitoring group or independent panel of experts to evaluate the rule of law. Now, it is my understanding that the Commission frequently uses kind of the independent experts to underpin the enforcement of its various policies while retaining the overall political responsibility. So I can't see any kind of legal or practical obstacles for using the services of independent experts in this case. So would you agree that this independent review is essential for it to be objective and neutral?
Thank you, Mr. Smecker. Mr. Reynders, there you go again.
Thank you. Thank you. I don't have any problem to work with independent experts, and the Commission is doing that. We are working with the Venice Commission, with the Greco, with a lot of other group of experts. But there is a responsibility from the Commission in front of the Parliament. And so if you have a list of other independent bodies that it's possible to consult and to ask to give an advice about the rule of law, but also fundamental rights on democracy, I don't have any problem on that. The problem is to see if we install a new independent body with a responsibility and maybe without the same kind of approach. If it's to give to an independent body the full responsibility to express the view of the European Union, it's maybe strange, because that is the role of the Commission to come before the Parliament and the role of the Parliament to decide. And then, last remark, of course, if we have a real problem, there's another level, is the Court of Justice, and there it's possible to receive some standards. So I'm not against some possibilities to consult and to discuss with independent experts, independent bodies, but maybe not to create a new one.
Thank you, Mr. Reynders. Now it's the time of the Greens. Madame Saskia Bricmont, vous avez la parole.
Monsieur le Président, bonjour.
Thank you, Chair. Good morning, Mr. Reynders. The EU is a global actor. They have cooperation agreements in terms of trade, justice, police or migration agreements. You said in your written responses that we need to be promoting our standards and our values to our international partners, that you would focus on the internal and external dimensions of your mandate, that you wanted to improve judicial cooperation between European authorities and third countries, and that those people involved in criminal matters have to have their rights protected all along of the proceedings. My questions are, do you make a commitment to carry out a systematic impact assessment on the respective human rights under such agreements? How would you ensure these human rights are respected when we look at, for example, the negotiations between Europol and countries in the north of Africa? And how would you work with your colleagues when it comes to these agreements, trade agreements and migration agreements?
Merci, Monsieur le Président. Merci, Madame Bricmont.
Thank you very much, Chair. Thank you very much, Mrs. Bricmont. Yes, I think it is a good idea to have impact assessments. I think we need to do that for a whole series of different initiatives that we're taking in the EU. I think that's the way we need to approach things when we are dealing with third countries. This is a commitment made by the President-elect, but I can also make this commitment in areas that fall under my remit. I want to inform Parliament and Council at each phase of the negotiations, and the impact assessment will, of course, be part of that analysis. I will do it, of course, first of all, in the areas that are part of the justice portfolio, but it's clear that there is work to be done together with other commissioners within the Commission in the area of home affairs. You talked about the negotiations that Europol are having with a number of partners, and I think here we will have to pay very close attention to human rights as they fit into the final agreement. In the area of trade in the Council, I've often been part of such debates. I think it is important that we look more closely at human rights in trade agreements. This is a debate that has evolved over time, but it affects our policies that we maintain with third countries. We